Wickard v. Filburn. This case was decided in 1942, and it's a good companion case to read with Gibbons v. Ogden in the jurisprudence, or the history rather, of the Commerce Clause of the U.S. Constitution. Now, the Commerce Clause is one of the most potent sources of power in the U.S. Constitution, and it became that way through decisions of the U.S. Supreme Court. Now, Wickard v. Filburn involves Farmer Filburn. He was an Ohio farmer who was growing too much wheat, according to the Agricultural Adjustment Act of 1938. Now, this was a law that the government had passed under Franklin Delano Roosevelt, which was attempting to control the supply of wheat and the prices of wheat. The government was concerned there was too much wheat and the prices were too low, and people were getting their bread for too cheap, and this was causing havoc in the economy because everything was too cheap. So they passed this law to control the supply and control the prices. And Farmer Filburn was growing too much according to his government allotment. And he argued that, look, hey, I'm keeping this wheat on my property. You know, I'm baking my own bread with it. I'm feeding my own cattle with it. Therefore, it shouldn't count. Well, writing for the court was Justice Robert Jackson. And Robert Jackson looked back at Gibbons v. Ogden and said, look, John Marshall himself, the great Federalist, said that the Commerce Clause has an embracing and penetrative power. And this power can only be reined in by the political process, not the judiciary. And he said that if the activity that is looking to be controlled has a substantial economic effect on interstate commerce, then it's constitutional. Well, what determines whether an activity has a substantial economic effect on interstate commerce? Congress does. So if Congress says it does, then it's constitutional. And that was kind of the law until the Lopez decision.